13 million green card holders in America woke up this morning not knowing that the United States Supreme Court is deciding right now whether they can be detained at the border, not because they did something wrong, but simply because the government suspects they might have. No trial, no conviction, no clear evidence, just a suspicion. And if the court rules the wrong way, the next time you or someone you love returns home from a trip abroad, everything could be different. This is not a warning about the future. This is happening right now. Welcome to Global Entry News. Subscribe right now and turn on notifications, because this ruling could drop by July, and you need to be the first to know. If you are a green card holder, or if you have a family member who is, what I am about to walk you through today is one of the most consequential immigration developments in years. A case is being decided at the highest court in this country that could reshape the rights of nearly 13 million lawful permanent residents. And by the end of this video, you are going to understand exactly what is at stake, who it affects, and what steps you can take right now to protect yourself and your family. Let us start with the foundation, because understanding this case requires understanding what a green card actually represents in the eyes of the law. Lawful permanent residency, what most of us simply call a green card, is the immigration status that sits above a visa but just below citizenship. As of January 2024, nearly 13 million people held this status in the United States. These are people who live here legally, work here legally, pay taxes, build businesses, raise families, and in many cases have called America home for decades. One of the most important rights that comes with a green card, one of the things that makes it so meaningful, is what is called the presumption of returning resident status. That means when you travel abroad for a wedding, for work, for a family emergency, and then you come back, you are treated as exactly what you are, someone coming home. That presumption is now at the center of a battle at the United States Supreme Court. The case is called Blanc versus Lau. The justices heard oral arguments on April 22, 2026, and a decision is expected by early July 2026. The central question before the court is this: can immigration officials place a returning green card holder on what is called the inadmissibility track, essentially a deportation pathway, without already having clear and convincing evidence at the time of re-entry that the individual committed a disqualifying offense? That is the question. And the answer the Supreme Court gives will affect millions of real people across this country. To understand why this case matters so deeply, you need to know the story of the man at the center of it. Muk Choi Lau is a Chinese national who became a lawful permanent resident of the United States in September 2007. In May 2012, he was arrested and charged in New Jersey for allegedly selling counterfeit goods. Shortly after that arrest, he briefly left the United States and returned in June 2012. And that is where the legal crisis began. When Lau returned to the country as a lawful permanent resident, immigration officials did not admit him as a returning resident the way the law normally requires. Instead, they placed him on what is called parole for deferred inspection. Now, the word parole in immigration law does not mean what it means in criminal law. This is not about being released from prison. Immigration parole is a legal category that puts someone in a kind of legal limbo. They are physically inside the United States, but they are not formally admitted. And that distinction carries enormous consequences. Here is why that distinction matters so much. Under federal immigration law, the standard of proof and the type of proceedings you face are completely different depending on whether the government treats you as someone who has been admitted to the country or someone who is seeking admission. If a green card holder is treated as seeking admission, they face what are called inadmissibility proceedings. These are generally much harder to defend against and carry broader consequences than the standard removal proceedings that would apply to someone who has already been admitted. In simple terms, being paroled instead of admitted puts you on a harder legal track with fewer protections, even if you have lived in this country legally for years. Now let us look at both sides of this argument clearly and fairly. The government's position, argued before the Supreme Court by the Assistant to the Solicitor General, is that border officers should not be required to have clear and convincing evidence of guilt at the very moment a person crosses the border. The government argues that evidentiary standards apply in formal legal proceedings before a decision maker, not at the airport. In other words, the government is saying that immigration officers at the border cannot be expected to conduct a full legal analysis on the spot, and that they should be allowed to gather and present their evidence later before an immigration judge. On the other side, Lau's attorney argued before the justices that allowing the government to parole a green card holder first and then justify that decision afterward opens the door to a dangerous expansion of government power. His attorney stated directly that the power to place green card holders in parole could be used for all it is worth, creating a very real risk that lawful permanent residents could be arbitrarily detained or placed in immigration limbo simply based on pending charges that have never been proven and may ultimately be dismissed. Immigration advocates who watched the oral arguments warned that if the government wins this case, every lawful permanent resident in America would have to weigh the risk of arbitrary parole and possible detention every single time they consider traveling outside the United States. Think about what that means in practice. The green card holder who needs to attend a parent's funeral abroad, the business owner who must travel internationally for a contract, the grandparent who wants to visit a sick relative overseas. Under the current legal framework, those individuals return home and are admitted. Under the framework the government is now asking the Supreme Court to approve, those same individuals could be paroled into the country based on a pending charge, one that has not been proven, one that may be dismissed, and then face removal proceedings on a far more difficult and unforgiving legal track. The justices themselves appeared deeply engaged with these concerns during oral arguments. One justice raised the concern that a motivated administration could use expanded parole power to place people in legal limbo rather than admit them, effectively using bureaucratic tools to suppress immigration without changing formal policy. Other justices pressed both sides on where exactly the evidentiary line should be drawn and what immigration officers at the border can realistically be expected to determine on the spot. Based on those arguments, legal observers have noted the court could split along ideological lines, and a ruling is expected by early July 2026. This is a live developing case, and the moment that ruling comes down, Global Entry News will have the full analysis ready for you. It is also worth placing Blanc versus Lau in the broader legal context of immigration decisions happening right now, because this case is not standing alone. Earlier in this term, the Supreme Court decided Urias-Orellana versus Bondi, which addressed the standard courts must use when reviewing asylum decisions made by immigration judges. That ruling tightened the standard for how federal courts can step in and challenge those decisions, with implications for thousands of pending asylum cases across the country. Separately, the court has been actively involved in disputes over the Temporary Protected Status Program. As of March 2025, nearly 1.3 million people from 17 countries were living and working in the United States under TPS protections, and a final ruling on TPS for Syrian and Haitian nationals is still pending. What all of this tells us is that the immigration legal landscape in America right now is in an active and significant period of change, and being informed is not just helpful, it is essential. So what should you actually do with all of this information? If you are a lawful permanent resident and you are considering international travel in the coming months, consult with a qualified immigration attorney before you go, especially if you have any pending legal matters, any prior arrests, or any criminal record, even for something minor, even for something from years ago. The Blanc versus Lau case is specifically about green card holders with pending criminal charges who return from abroad. Do not assume your situation falls outside the risk zone without professional guidance. Organize your documents. Your green card, officially Form I-551, should be current and not expired. If it is expiring within the next year, begin your renewal now by filing Form I-90 with USCIS. Keep copies of your green card, any re-entry permits, and documentation of your ties to the United States, your lease or mortgage, employment records, tax filings. These documents tell the story of who you are and how deeply rooted you are in this country. If you have any prior criminal matter, even one that was resolved, even one that was expunged, speak with an immigration attorney specifically. Immigration law and criminal law interact in ways that are not always intuitive, and what seems resolved in criminal court can still carry immigration consequences. Many nonprofit legal organizations offer free or low-cost consultations, and USCIS maintains a list of accredited representatives at uscis.gov. The information shared in this video is current as of May 2026 and is based on official sources including SCOTUS blog, Roll Call, Jurist, and Just Security, as well as official Supreme Court records and USCIS guidance. Nothing in this video constitutes legal advice, and no two immigration cases are exactly alike. Thank you for watching Global Entry News. If this video gave you clarity on something that matters to your life or your family's future, please hit the like button right now. It helps this information reach the people who need it most. Share this with anyone you know who holds a green card or is in the middle of an immigration process. They deserve to have this information. And if you are not yet subscribed to Global Entry News, subscribe right now and hit that notification bell, because the ruling in Blanc versus Lau is expected by early July, and we will be covering it the moment it lands. You do not want to miss that. Check the description below for links to USCIS resources and information on finding accredited immigration legal help in your area. You are not alone in this. Millions of people across America are asking the same questions, and this channel is here to make sure you always have accurate, trustworthy answers.